Right, hello, good morning, and a warm welcome to part 2 of the RTPI Northeast Planning for EIA webinar series. I don't call it a series because there's 2. I hope some of you were here for part 1, which was a very interesting session, and we're here now for a bit more detail and some other views from different speakers. As the morning progresses, if you have any questions, please send them in the questions box, and I will try and gather them. So if there's an emerging theme, but either at the end of that speaker's session or at the end of the whole session, we can have a discussion with the panel about any questions that you might have. So think about things that you've just seen, or just think about bigger issues that you want answers to, preferably related to EIA, that would be good. So you can just log those questions and put those there. We've got a range of speakers giving us a detailed picture of what is a very changing picture as well in terms of EIA. So it'll be interesting to see the different views that we get this morning. Jayne, one of our speakers, can't be actually on screen today, so Jayne is in stealth mode, so you'll be able to hear her, but you won't be able to actually see her. But I don't think that should be a problem. We will, I'm sure we'll enjoy her presentation. So everybody should be on mute anyway. Basically, if you've got questions, please ask them at the end, and I hope you enjoy the session. So our first speaker today, actually I should introduce myself first. Anyway, for those who don't know me, I'm Timothy David Crawshaw. I'm the Regional Chair of the Northeast RTPI, and I'm an urban designer with a lot of interest in this sort of stuff. That's me really. So our first speaker today is Jayne Oswald, who's an environment planner from Barton, Willmore. Jayne Oswald has worked, hello? Jayne, are you there?
Hello, sorry, yes.
Yeah, has worked as an environmental planner at Barton Willmore for 3 years and is a practitioner member of the Institute for Environmental Management and Assessment. Jayne has a wide range of experience in a variety of environmental and town planning projects within the residential, commercial, aviation, mixed use and energy sectors. Jayne leads on environmental impact assessments and undertaking other environmental and planning documents within these sectors and is responsible for ensuring robust assessments are undertaken for such developments to protect the environment, which Jayne has a keen interest and strong passion for. I give you Jayne.
Hi, thank you for that. Brilliant. Good morning all, and thank you for joining. So yes, my presentation will be focusing on the screening and scoping stages of the EIA process. Oh, sorry, I'm just trying to move this along. There we go. This is the brief agenda of what I will cover in the presentation. I'll just do a brief refresher on the EIA process and give a bit of an overview of the 2017 EIA regulations before moving on to the screening and scoping stages. So yes, first off, my name is Jayne Oswald. I apologise you can't see me today. My webcam is not working and I'm not sure why. I'm an environmental planner within the infrastructure and environmental planning team at Barton Willmore. We are an independent planning and design consultancy with 13 offices located across the UK. We as a team specialise in managing environmental risk through the planning process at both the strategic and project level, and we are accredited with the IEMA EIA quality mark. So just a bit of a refresher on the EIA process. This slide just contains a couple of quotes from different sources which explain what environmental impact assessment is. And so in a nutshell, EIA is just an information gathering exercise carried out by the developer and other bodies which enables a local planning authority to understand the environmental effects of a development before deciding whether or not it should go ahead. PPG offer a different definition, and they say the aim of environmental impact assessment is to protect the environment by ensuring that a local planning authority, when deciding whether to grant planning permission for a project which is likely to have significant effects on the environment, does so in the full knowledge of the likely significant effects and takes this into account in the decision-making process. So just a few quotes there. Sorry, there we go. The next slide provides a snapshot of the EIA process. So once a proposal has been identified, we go through the screening stage to determine whether EIA is required. If EIA is not required, then the EIA process does not progress any further. If EIA is required, we then move on to the scoping stage, where we engage with the council and statutory consultees to determine what's needed to be included with the environmental statement. From scoping, the technical team will then undertake their assessments of the proposal and identify mitigation and enhancement measures, which will form the environmental statement, which is then submitted in support of the planning application. Once submitted, the council consults on the ES and determines whether any further information is required, and if it is required, then an ES addendum will be prepared and submitted to the council. And then post-consent is when we implement the mitigation measures and monitor the effects. One thing to note here is that just because significant effects could be identified through the EIA process does not mean planning consent should not be given. It's just taken into account in the overall planning balance. So this slide just gives a bit of an overview of where we are at with the 2017 EIA regulations. So they came into force on the 16th of May 2017. The main changes from the 2011 regulations were mainly the inclusion of new topics such as human health, climate change, disasters, tweaks to the screening and scoping processes, demonstrating that ESs must be prepared by competent experts, and subtle changes to the ES content and structure. They were subsequently amended on the 1st of October 2018, and a key change here was the threshold criteria for industrial estate projects from 0.5 to 5 hectares. Were again amended on the 14th of May 2020 this year due to the coronavirus pandemic. This is just on a temporary basis, and mostly the changes revolve around the requirements of publicising ESs and the inspection of these documents. So screening. Screening is the process of deciding whether a proposal requires EIA. 2017 EIA regulations divide types of development into 2 groups for screening purposes. For Schedule 1 projects such as nuclear power stations or the construction of motorways, EIA is mandatory. For projects that fall within Schedule 2, such as your housing developments, regen projects, which is where I mostly deal with, EIA will be required if there are likely to be any significant environmental effects. To determine whether EIA is required, we then consider the criteria set out within Schedule 3 of the EIA regulations. We need to look at the characteristics of the development, the location of the development, the characteristics of potential impact. So the screening practice has become much more involved over the past 5 to 10 years, and while it used to be the case that a red line plan and some broad materials were sufficient to which to adopt and rely on a screening opinion, this really isn't acceptable anymore, and the more detail that we can provide up front, the better position we are in to produce a robust screening report that can be relied on as the plan application progresses and ensures that only the proposals are likely to have significant effects on the environment are subject to the EIA process. That is not to say that all technical planning reports should be prepared in advance. That EIA can be screened out. If any draft technical reports or initial or preliminary technical notes are available, these would be helpful and provide scientific evidence and reasoning to screen out the need for EIA. As stated in Regulation 6, paragraph 2, a screener report should include any measures envisioned to avoid or prevent what might otherwise have been significant adverse effects on the environment. On my next slide, I have an example of how we've done this and how we continue to do this within screener reports. And it's just providing the confidence for the council and for the applicant, you know, that those measures are provided up front, so a robust screening opinion can be provided. Another requirement of the 2017 EIA regulations is the consideration of cumulative effects of a project and other existing or approved developments. There isn't much available guidance on how to conduct cumulative assessments, but from best practice, we use a distance of approximately 2 kilometres from the site to identify cumulative schemes for screening. For London schemes, we tend to look on a smaller scale than that. That tends to be about a 1 kilometre radius. And the key tests for screening, which are identified within the EIA regulations and the PPG, are the proximity of sensitive areas as defined by the EIA regulations to the site. So these include areas of outstanding natural beauty, scheduled monuments, Ramsar sites, special protection areas, special areas of conservation, sites of special scientific interest and national park. And we also look at the scale of development, traffic generation, associated emissions and contamination. So I've included here an extract from a recent screening report we have done for a 260 unit housing scheme, which demonstrates how to incorporate upfront mitigation into screening reports. This extract sets out the description of the development and then goes on to discuss plain and uncontroversial mitigations that have been incorporated into the proposals and what the applicant is comfortable with agreeing to upfront. And then a noise report, flood risk assessment and a biodiversity report were all attached to the request. So having set out the information in the screening report, the next key stage is to ensure that the local planning authority have taken those measures into account in the determination process, and that the adopted screening opinion sets out clearly what measures they have included and considered to comply with Regulation 5, paragraph 6, as shown on this slide. With regard to the timescales, the local planning authority should adopt their opinion within 3 weeks. However, the point note here is that a local planning authority could take up to 90 days if agreed with the applicant to adopt a screening opinion. In addition, the 2017 EI regulations requires the main reasons behind their decision should be stated within their screening opinion. And we as a practice go through the screening opinion to make sure that they have picked up everything that we wanted them to, and we've set out in the screening report. And here is an example of this. Here's an extract from North Lincolnshire Council's screening opinion in respect to the proposed development for long-term production of hydrocarbons at an existing temporary exploratory well site in North Lincolnshire. It was proposed as part of the development that if sufficient volumes of gas from the production operations were produced, this will then be used to generate electricity and will be circulated back to the national grid. However, as a mitigation measure, it was proposed to have an emergency flare on the site that would combust gas volumes in the event of an emergency, such as if excess gas is produced. The importance of this mitigation measure was captured in North Lincolnshire Council's screen opinion, as shown in this extract, which complies with Regulation 5, paragraph 6 of the 2017 EI regulation. So if through the screening process it's determined that EIA is not required, then the process stops here. If EIA is determined, then we move on to the scoping stage. Scoping is not a mandatory process, depending on what your previous knowledge of the site is, or whether an ES has been prepared for the site in the past, or if the project is confidential and the applicant does not want it in the public domain, the scoping process can be skipped, which we have been able to do on certain occasions. However, scoping does remain good practice, and this does reduce the chance of a Regulation 25 request from the Council for further information. The scoping process is where technical disciplines and assessment methodology to be included in the environmental statement is agreed with the local planning authority. During this process, the LPA will contact Dutch consultees for their input to provide a scoping opinion on the project. The 2017 EA regulations state that the ES must be based on the most recent scoping opinion issued by the local planning authority, and this is crucial for all ESs. One of the main changes in the regulations, as I mentioned previously, is the inclusions of these new topics: climate change, accidents, disasters, and human health. We as a practice have been able to scope out climate change and accidents and disasters to date. However, a couple of recent scoping opinions have started to request for individual chapters on these topics, and we anticipate that this will keep happening as as the current situation evolves and climate change is very topical at the moment. Across the industry, there is the increasing recognition that many environmental statements are not appropriately assessing the expected significant effects of the development. Within the wider EIA practice, there is a big push being made to make EIA more proportionate instead of producing unnecessary lengthy documents. EIA scoping process is a very useful tool to undertake to ensure the applicant and the LPA agree on a proportionate approach to the ES, which focuses on key significant environmental effects a proposal could potentially have on the environment. IEMA have published guidance on how to deliver EIA, and they have identified several aspects to deliver proportionate EIA, and these include having a strong competent scope and providing upfront scientific evidence and justification as to why you might not need to scope in certain technical disciplines. use of competent experts to ensure that only significant effects are addressed, and increased use of digital EIA, which is coming more and more topical. And I believe IEMA have a working group working on this at the moment. And yeah, so hopefully a big push on the digital side for the future. That's all I have to say today. If there are any questions or anything, please let me know. But thank you for listening.
Smashing, thank you very much. It's always strange with these things, isn't it? That, that you can't have a round of applause, although we'll try. So, hey, thank you.
Thank you.
I'm sure everybody at home is doing that the same, although muted. I mean, we've got a short time here for some questions, and I had one really, and I think it's probably relates to COVID, which kind of everything does at the moment. But in your experience, what's happening in terms of the performance of being able to get a screening opinion in a timely sort of fashion, really, given the fact that in a lot of cases the wheels seem to be grinding to a halt in terms of decision making and stuff. I don't know if there are any insights on that or what revised expectations might look like.
Sorry, Tim, you just dipped out for a second there, so I missed the first part of the question. Sorry.
The question was, in your experience of what's happening now, are you finding that there's a lot of delays in terms of getting a screening opinion?
To be honest, no, not really. I think things are still moving. They are still moving, and it hasn't been significant delays. I mean, scoping opinions are more of the ones where we're seeing a bit more delay of getting statutory consultee responses back in time, and councils wanting to delay issuing their scoping opinions until they've had these responses back from their statutory consultees. So that's where I personally have been seeing more of the delays, and I think that's just because, you know, COVID situation, working from home and etc. Things are just taking a tad longer. Yeah, that's what I've kind of experienced so far to date.
Yeah, it's challenging times for everybody really at the moment, isn't it? So,
yeah.
Yes. Yeah. And I suppose the other one that comes to mind is, and this is, you know, around skills as well. I mean, are you finding that the reliance on external people is potentially holding things up, and is there, you know, are there sufficient skills in the system really at a local level? Yeah.
A couple of my schemes that I'm working on at the moment, we are increasingly seeing the council outsourcing expertise, especially with traffic, transport consultants, etc. So in really topical, disciplines, we are seeing them outsource these expertise, and I think that's also just because of the scrutiny ESs do get, and we want to ensure, obviously, we are taking a robust approach to these developments, and then the council again want to get it right and avoid JR risk, etc. So yes, we are. I have started to see more of that happening.
Yeah. Cool. Okay. Well, thanks very much. Join us for the panel discussion later. While we're talking about things like potential challenge and everything else, I think it's time I introduced Martin Carter, who's a barrister for King's Chambers. Martin undertook his pupillage at King's Chambers and spent his entire practicing career with Chambers. He undertakes advisory work and appears at inquiries and the courts at all levels, including the Supreme Court. His practice includes all areas of planning and environmental law, with particular experience of housing where 5-year supply and/or needs assessment is an issue, renewable energy, retail, minerals and waste. He also undertakes work in relationship to environmental law, particularly with regard to environmental impact assessment and strategic environmental assessments. Martin has promoted many local plans at examination and also appears for objectors at examination hearings. He also practices in the field of compulsory purchase. So, ladies and gentlemen, I give you Martin Carter.
Thank you very much, Tim, for that introduction, and it's very good to be with you all. Usually when asked to do a case law or legal update for EIA matters, you're taking on a fairly large task. But this year, it's not particularly onerous to give you a legal update on EIA cases, because there haven't actually been that many, as I'll go through. So in order to make sure that we had sufficient to talk about, and because it's topical and interesting anyway, I've also slightly bent the topic and shoehorned the white paper into legal updates in order to sort of have a quick discussion about what the white paper is saying about proposed reforms to the EIA system. When as I've set out, 2020 has been a relatively light year. I think there are probably two reasons for that. I think that the courts have consistently said over the years that the EIA process should not be an obstacle course, but it should be an aid to decision making. And I think that the court's exhortations over the years are beginning to be taken on board by people. And I also think that there is a degree to which all the main points in the EIA regulations have largely been litigated beyond doubt. EIA has been with us since 1988, and although the regulations have been updated at various points in time, the amendments have been fairly minor on the whole over the years. And I think what we're seeing is that the main issues have come to be resolved. So the first of the three cases that I've got to tell you about this morning is the case of Kenyon and the Secretary of State. It's a Court of Appeal decision from earlier in the year. And like the other two cases I'm going to tell you about, it's a case about a screening decision, in this case, a screening direction made by the Secretary of State. It was a site on the edge of Hemsworth near Pontefract, which had a significant planning history. There had been two judicial reviews of planning permissions which had succeeded in the past. And the latest attempt involved a scheme of 150 units. The Secretary of State had decided that the scheme was not EIA development. And as Jayne's helpfully reminded us all this morning, EIA screening is only really relevant to Schedule 2 development to decide, firstly, whether a project's within Schedule 2, secondly, whether the relevant size of site threshold is exceeded or not. And then if both of those things are decided in a particular way, you then have to go on and consider whether there are likely to be significant environmental effects from the scheme. And likely means a real risk rather than more than 50% prospect of. The Secretary of State decided that the scheme was not EIA development, and that was the subject of a judicial review challenge. The challenge was only allowed to be brought on one ground, which related to the way in which the cumulative effects of air quality had been addressed. And that had failed in the High Court in front of Mrs. Justice Lang, and the claimant went to the Court of Appeal. It's fair to say that the challenge crashed and burned, I think. It was very comprehensively rejected by the Court of Appeal. It was, in essence, what the claimant tried to do was to mount a very detailed factual challenge to the way the Secretary of State had gone about the direction, dressing up the arguments as an argument that the Secretary of State hadn't got an evidential basis for the conclusions that he had reached. But the way that the claim was pursued did not impress the Court of Appeal. There were attempts to rely upon late evidence to try and prove the case, including evidence that actually post-dated not just the Council and the Secretary of State's consideration of the matter, but even evidence that post-dated the High Court's consideration of the matter, which went down very badly. The one ground that permission had been granted for actually ended up being 5 attempted grounds in the Court of Appeal, which didn't go down well with the Lords Justices either. And there was what the court called challenge creep, in that there was a not very subtle attempt to move the goalposts in relation to the tasks that had been allowed to be pursued. If you're arguing that there has been no sufficient evidential basis for a conclusion reached in relation to a screening decision, you have always got an uphill task as a claimant. Because if the regulations have not been misinterpreted and you've addressed the question of whether something is Schedule 2 development or not in a legally robust way, the only way in which a screening decision can be challenged is on irrationality grounds, what we also known as Wensby unreasonableness, a decision that's so unreasonable that no reasonable person could have taken it. And against that background, claimants also got the difficulty that EIA screening is deliberately designed to be a preliminary broad-based assessment undertaken by people who've had relevant training and planning expertise. That's a quotation from paragraph 43 of the judgment. And the court continually emphasised through this judgment that there is a matter of planning judgment involved in reaching a judgment about a screening decision, and it's not very easy to find legal grounds in order to be able to challenge that. You can see how unimpressed the court were with the challenge by the amount of references that there are to that matter in the judgment. They agreed with Mrs. Justice Lang, who called the challenge unduly forensic and nitpicking. There were lots of other judicial expressions of disappointment about the over-legalisation of planning processes. And in fact, Lord Justice Coulson went so far as to say in the second paragraph of his judgment, I wondered if the most important point to arise from the appeal hearing was the need to ensure appeals in cases of this kind do not become another weary trot around a well-worn course. Not the sort of thing you want to read as an advocate when in a Court of Appeal judgment. The way in which the claimant went about arguing the case was to try and point to the lack of evidence, but in fact what they were really doing was picking holes in the value judgments that had been reached about the quality of the evidence, and the court came to the conclusion that the challenge came very far short of pointing out that there was any legal error. And indeed, the Court of Appeal noted that there was no attempt really to try and explain why Mrs. Justice Lang had got the decision wrong, which of course is what you should be doing in the Court of Appeal, but rather the claimant had gone back to the original documents and simply tried to re-argue the challenge as though the Court of Appeal was the first instance court. The claimant also tried to tack on an argument about invoking the precautionary principle, and they said that because there was some inevitable uncertainty about the air quality impacts of the scheme, it ought to be concluded that EIA was required in order to comply with the precautionary principle. That argument too was given short shrift by the Court of Appeal. The precautionary principle only applies if there is reasonable doubt in the mind of the decision maker about the relevant issue that they are considering. Here, there was none, and so there was simply no room for the precautionary principle to apply in the first place. This case doesn't really say anything new, but it is valuable reinforcement of the principles that have emerged over recent years, and it's an object lesson in the difficulty of trying to challenge screening decisions, and it's indeed a good lesson in how you will not be met kindly if you try and argue points of judgment dressed up as points of law. The next case is the rather interestingly titled "The Crown on the Application of XSWFX and Ealing London Borough Council." This is a decision of Mrs. Justice Lang in the High Court, and it's again a case that's connected with screening. Ealing Council had granted planning permission to QPR Football Club for a new training ground and academy and various other facilities that involved the importation of a large amount of waste in order to level the ground up. The planning permission had been challenged in the High Court and the Court of Appeal, but the challenge failed, and there had been planning conditions attached to the permission requiring an ecological construction method statement and an ecological management plan prior to the commencement of development. And at no stage during the processing of that first planning application had the scheme been screened for EIA, and for reasons that I can't get to the bottom of from reading the judgments, that lack of screening was never part of the initial challenge. When the developer came to discharge the ecological conditions with the planning authority discharged them without screening those conditions for EIA purposes to see whether an environmental statement should be required at the time when the conditions were discharged. And that was what prompted the judicial review application, which sought to challenge the decision to discharge the conditions without first screening that exercise for EIA purposes. The hearing was in fact an oral permission hearing because the case had been thought to be too complicated to be dealt with on the papers, and Mrs. Justice Lang noted that screening covered subsequent applications as well as the original development consent, in the words of the directive or granting planning permission decision itself. The planning authority conceded that it hadn't screened the decision to discharge the conditions. QPR accepted that that had been the case, and so it was very obvious that a legal error had been made. But the planning authority, supported by QPR, tried to argue that it was highly likely that the decision would have been the same had the discharge application been screened, and so they tried to argue, in accordance with the new version of Section 31 of the Senior Courts Act 1981, that the court should not quash the decision as a matter of its discretion. That argument didn't succeed because after a review of the evidence, the judge concluded that the planning authority couldn't show that the decision was highly likely to be the same in any event. But she also concluded that in a case like this, where you've got an EU obligation rather than a domestic law obligation, EU law tells us that it's not enough for the decision maker to show that the decision was highly likely to have been the same. The decision maker has to show that the decision would have been the same. So that was another reason for not allowing the decision to stand, and it was quashed. And if you're wondering why the case has a rather strange case title, it's because the claimants were receiving death threats, apparently from QPR fans, and so they were granted anonymity in the processing of the application to make sure they weren't put at any undue risk. So that's the second case I wanted to tell you about. The third case and the final case is the case of Swire and the Secretary of State. Again, another decision of Mrs. Justice Lang, and it's another challenge to a screening decision. The development in this case was proposed on a site which had been used in the 1990s for the burial of cattle which had been slaughtered during the BSE crisis, and they were cattle which had had BSE. And it was common ground that the site was contaminated by that and by other activities in the past, but comprehensive remediation was planned as part of the development proposals. The way in which this had been looked at by the council, there had been no fewer than 3 reports prepared on land contamination, but none of them actually addressed the BSE activity. There had been some exchange of email correspondence where the planning authority thought that any risk was negligible because the contamination would have been dissipated over time, and that was what the Secretary of State largely relied upon when coming to the conclusion that the scheme was not EIA development. In short, the court held that that was not a good enough approach, because although screening decisions, as Jayne has set out again earlier this morning, can take into account the ability to secure mitigation by conditions, you can't just assume that mitigation would be effective. You can only really take account of measures whose nature, availability and effectiveness are already well known, well established and uncontroversial. You can't take account at screening stage of measures if they are not plainly uncontroversial. And in this case, the Secretary of State accepted that the remediation measures were not supported by full information. More investigation and assessment would be required. And so the court concluded that likely significant effects could not have been ruled out properly at the screening stage, and particularly given that we remind ourselves that likelihood really means more than a bare possibility. And so the screening direction in that case was quashed too. So although there have been only 3 cases this year, it's interesting to note that in fact 2 of them succeeded. So then turning finally and quickly to the planning white paper, lots of things in the planning white paper, lots of interesting things that are hitting the news and becoming politically controversial. One of the things that the white paper does is to say something about environmental impact assessment. But I can deal with this very briefly because it sort of tantalizes us with what the government's thinking is, but gives us no detail. EIA is set out in the white paper as being part of a complex, opaque and bureaucratic planning system that contributes towards causing delay. We're told that EIA produces overlong reports which are opaque. They do very little to secure environmental improvements. And the government floats the ideas of introducing a quicker, simpler framework for assessing environmental impact and opportunities, which speeds up processes. They say they're going to strengthen the way that environmental matters are considered, and they are going to make the assessment of environmental matters take place much earlier in the process. And that's obviously all tied up with the local plan reforms and the idea that growth areas are going to grant outline planning consent when the plan is adopted. And so the environmental matters will have to be done and dusted by the time the plan is adopted. And there's going to be a greater emphasis on environmental improvement. Well, all that sounds great. How is it to be done? The honest answer is I have not the faintest idea, because the white paper doesn't tell us any more than the bare bones of what I've just set out to you in 30 seconds flat. And the white paper tells us that it's going to be the subject of a separate and more detailed consultation in the autumn. So we will have to wait and see what comes down the track a little later on in the year. That's what I propose to tell you. So thank you very much for listening.
Smashing. Thanks very much, Martin. Woo, thank you. Right. So thank you for that. There's one question that came to mind while you were speaking, which was around the EU and obviously our departure. In terms of the positions, I think you touched on the fact that one of them was it was a higher bar almost, wasn't it, in terms of where EU regulations and law come into respect. Do you see a massive change in how things are going to operate the other side of this?
Not immediately, no, because the way that the withdrawal legislation works is to simply move all the EU law into our law for the time being. So and then the government are giving itself a free hand to legislate in the future. I think if the white paper is anything to go by, the government do want to make fairly substantial changes and make it what they would call a less bureaucratic and more transparent and more effective system in terms of securing improvements. But how they're going to go about it, I'm afraid, is anyone's guess at the moment.
Well, yeah, I mean, the concept to me is one of the things that if it's done in the right way, it's a common platform for every stakeholder to be fully aware what the decision making and taking process looks like and what the considerations are. So I can't imagine that there'll be many groups who will just roll over and say, well, actually, we don't want any of this, because actually it protects everybody as much as you know, protects the environment. So I think there's that too. So brilliant. Okay, great. Well, thanks very much. That's fantastic. I'll move on to our next speaker. Thanks very much, Martin. And I'm going to introduce to you now Sue Birnie from Wood Group. Sue is an Associate Director at Wood, a member of the Royal Town Planning Institute, and has over 20 years experience in planning, coordination of environmental impact assessments and project management in both consultancy and local government. Sue is based in the Newcastle office at Wood and works on large-scale infrastructure projects such as Section 36 developments for wind farms in Scotland, as well as minerals, waste and smaller-scale renewables. She provides planning advice and the planning strategies for developments, consultation advice for public exhibitions and consultation meetings. Sue leads an EIA project team and provides reviews of EIA applications before submission. I give you Sue Birnie.
Hi, thank you very much. So I'm an EIA project manager and I coordinate project teams and prepare the technical chapters and then pull together the EIA and review it and then submit it with accompanying documents. And I work for a company called Wood, which has interests in a huge number of areas, and a small part that I work in is focused on the environmental permitting and planning side of things. And we provide expertise to a wide variety of environmental infrastructure and mineral resource projects. So, fingers crossed. So this is just the contents of the presentation, and this presentation is about EIA development post-submission. I'll run through what is required for an ES to comply with Regulation 18, and where it doesn't, explain what can be done to request further information. I'll then talk about what's required on issuing a decision. After the applicant has offered to submit an EIA, or after the Council or Secretary of State has issued a positive screening opinion, an applicant should prepare a scoping request. A positive screen is basically a development that would have likely significant effects and therefore required to be accompanied by an EIA. A scoping request isn't mandatory, but where one is submitted and the Council or Secretary of State have issued a scoping opinion or direction, the subsequent environmental statement must be based on that scoping opinion or direction. And at Wood, we tend to include a section in one of the front end chapters of an environmental statement which sets out what the scoping opinion required and a reference to which parts of the environmental statement address it, and it's usually set out in a tabular format with signposting. And this gives a quick visual reference to compliance with the scoping opinion. The regulations also require that the environmental statement is to evidence the competence of the experts, and at Wood we tend to set out what, in one of the front end chapters, the author and the reviewer of the technical chapter, together with their qualifications, the membership to relevant professional bodies such as the RTPI, and also the years of experience that they have. So information for inclusion in environmental statements. The local planning authority should check that the submitted environmental statement contains all the information specified in Regulation 18, and as appropriate, any additional information specified in Schedule 4 of the regulations, which is relevant to the development and the environmental features likely to be significantly affected. And this slide just sets out the list of what's required for an environmental statement to be adequate, and further information of this is set out in Schedule 4 of the regulations. In terms of point number 4, this relates to population, human health, biodiversity, land, soil, water, air, climate, material assets, cultural heritage and landscape. And also in terms of point number 6, this particularly relates to a description of the forecasting methods or evidence used to identify and assess the significant effects on the environment, including details of difficulties, for example, technical deficiencies, or perhaps a lack of knowledge that would be encountered when compiling the required information and the main uncertainties involved. There will be instances where the case officer reviewing the environmental statement and all the consultee responses identify that there are gaps in the environmental information submitted with the environmental statement. The EIA regulations provide for this in Regulation 25, and this allows the local planning authority to request further information. And it's important to distinguish and correctly identify information gaps and whether it relates to the environmental statement to make it adequate, or whether it's just information that's helpful or necessary to have to assess the planning merits of the proposed development. So Regulation 25 states that if a relevant planning authority, the Secretary of State or an inspector is dealing with an application or appeal, as the case may be, in relation to which the applicant or appellant has submitted an environmental statement, and are of the opinion that, in order to satisfy the requirements of Regulation 18, it's necessary for the statement to be supplemented with additional information which is directly relevant to reaching a reasoned conclusion on the likely significant effects of the development described in the application in order for it to be an environmental statement. The relevant planning authority, Secretary of State or inspector, as the case may be, must notify the applicant or appellant in writing accordingly, and the applicant must provide the additional information. And such information provided by them is referred to in the regulations as further information. And requests for further information should be limited to the main or significant environmental effects to which the development is likely to give rise, and must be on relevant matters and directly relevant to reaching a reasoned conclusion on significant effects. So basically, an environmental statement doesn't need to include every conceivable bit of environmental information about a particular project, and if a request for further information is made by the local planning authority, it must be made in writing. An applicant can also volunteer additional information, and this is called any other information in terms of the wording of the regs, and any other information of a substantive nature submitted voluntarily by an applicant must be treated in exactly the same way as if it was requested by the local planning authority under Regulation 25. The key point to consider is whether any information on environmental matters provided to the decision maker subsequent to the initial application and ES submission is information that is necessary for an adequate environmental statement. In other words, an environmental statement that complies with the requirements of the EIA regulations. So why is it important to correctly identify the information? Specific publicity and consultation requirements apply to requests for further information under the regulations, and we've not touched on that today. If it's not correctly interpreted and the information is requested, but they're not advertised in the correct way, it provides a potential route for challenge. And if an environmental statement isn't adequate and doesn't provide the decision maker with the required information to enable them to make a decision on the likely significant environmental effects, this also provides a route for challenge. And if information is requested under Regulation 25, but it isn't necessary to make the environmental statement adequate, there could be unnecessary expense in terms of consultation and publicity, and then further delays. Planners may want to make requests for information to support a plan application accompanied by an environmental impact assessment, and there might be a number of those requests. And one suggested way of doing this is to clearly set out what is considered to be Regulation 25 requests for further information, and secondly, what are clarifications. Further information requests relate to information requested to ensure compliance with the requested to ensure compliance of the environmental statement with the regulations, whereas a clarification are there to aid the understanding of what's been submitted in terms of an environmental statement. And for clarity, it's suggested that requests for information not pertaining to the EIA should be made separately as well. And this information might be things like cross-sections or additional information to justify the type of road access, or further details on floor plans. The 16-week time limit for determination of EIA application continues to run throughout the correspondence about the adequacy of the information. And the LPA can't consent an environmental impact assessment application for 30 days from sending to persons that was sent the copy of the original ES, or from the newspaper notice, or the data publishing on the website, whichever is the latest. And you need to be aware that information submitted to provide clarification could end up being information on the main environmental effects directly relevant to reaching a conclusion on significant effects. And it's up to the planning officer to judge whether any further information or any other information is integral to the adequacy of the environmental statement and therefore requires formal publicity. And where the planning officer judges that this is to be the case, the request for further information should be made as soon as possible in order to reduce potential delays in determining the proposal. And it's helpful for developers to have the further information requests clearly articulated so there's no ambiguity in what the local planning authority wants. So take care if the request for further information under Regulation 25 hasn't been complied with, and Regulation 26 states that the local planning authority must not grant permission unless satisfied that the reasoned conclusion of the significant effects of the proposed development on the environment, taking into account the examination of the environmental information, is up to date. And this basically means that if you request further information under Reg 25 and you haven't got it, you shouldn't grant consent until you've received, consulted on, and assessed all the information to make the adequate environmental statement. Further requests under Regulation 25 can also be made, and further requests under Regulation 25 can be made if further information provided by the applicant is still inadequate, or if it raises new points that require further information. And a planning officer's work isn't finished once a decision's been made on an EIA application. Regulation 30 places a duty on the local planning authorities to inform the Secretary of State of the decision in writing, to inform consultation bodies of the decision in writing, and these are identified in the regulations and include bodies such as Natural England and the Environment Agency, and inform the public of the decision by local advert or by other such means as reasonable in the circumstances, and make available for public inspection where the planning register is kept a statement containing details of the matters referred to in Regulation 29, which relates to the right to challenge, and if consent is granted, the conditions, the mitigation and the monitoring requirements of the EIA, and if consent is refused, the reasons. And then in addition to that, must also include in the statement the main reasons and considerations on which the development is based, including, if relevant, information about the participation of the public and a summary of the results of consultation undertaken, and information gathered in respect of the application and how the results have been incorporated or otherwise addressed. And all of this must be done promptly. And these duties also apply to the local planning authority where the EIA application or appeal is determined by the Secretary of State or an inspector. So this is kind of the last slide, just a bit of an example or three in terms of some case law. Where planning policy constitutes substantive information when submitted voluntarily was considered in the Bishops versus East Herefordshire case. And in this case, the submitted environmental statement, including a planning policy section for which an environmental statement addendum was subsequently submitted to record changes resulting from the publication of the NPPF. This addendum wasn't publicised by the council, and this fact was the subject of a challenge to the planning consent. However, the court held that the submission of the ES addendum, because of the adoption of the NPPF, wasn't substantive information, and therefore there was no need for it to be advertised, and there was no technical breach in terms of the EIA regulations. In Jenkins versus Gloucestershire, which was part of the 2011 EIA regulations and therefore referenced to Regulation 19, an advisory note on flood risk was provided by the applicant, which was in response to an objection by the Environment Agency to the planning application. The advisory note had not been requested by the local planning authority, and it therefore wasn't further information as defined by the regulations, and the local planning authority didn't publicise the information. The judge stated that it was substantive information related to the environmental statement, and it was provided by the applicants for planning permission. The information sought to address objectors' concerns on a significant issue, namely flood risk, by giving a description of the measures envisaged in order to avoid, reduce, and, if possible, remedy significant adverse effects. It was therefore considered to be any other information and required to be advertised. The judge found that there had been a breach in the advertising requirements of the EIA regulation. And the final example, Corbett versus Cornwall, it's much easier to say. The claimant contended that there was a failure to disclose certain documents and make them publicly available, or to notify the public of their existence. And these documents constituted environmental information which needed to be made public prior to the decision being made. The documents in question were correspondence between third parties and the developer, which were to respond to their concerns or points raised by them, information and studies to address the concerns of consultees, information submitted by third parties to the council, and information generated by the council. The claimant submitted all of these as any other information, as they were considered to be substantive information relating to the ES and should therefore have been publicised. However, the court held that further information means substantive information provided by the applicant to ensure that the council is provided with the information required for inclusion in an environmental statement as required by Schedule 4 of the regs. If such information is provided voluntarily by the applicant, it would be any other information. If requested by the local planning authority, it would be further information. Both have EI publicity requirements attached to them, and the key issue in this case is what constituted any other information. The court held that any other information didn't include comments or responses made by the applicant in response to the concerns of or points raised by third parties or council officers, documents submitted by third parties or generated by the council, and such this information wasn't subject to public notification required in terms of the EIA regulations. So they took a bit of a different stance. Thank you very much for listening. That's all of my slides, and open to any questions.
Thank you, Sue. Brilliant. Thank you very much. Yes, well, we've got some questions. We're getting short on time. Thanks very much for presentation. If I could bring the rest of the panel back, and it may be that we can ask these questions to the panel. Is everybody there? Yay, brilliant. There's Martin, brilliant. Okay, so questions from the panel. Quick question regarding competent experts. What is considered to be competent for EIA coordinator roles? Has this ever been challenged before and a plan application been refused?
Do you want me to have a go with that?
Oh, have a go, Sue. Go.
We haven't been questioned on it before, and as far as I know, we haven't been challenged on it at Wood. I think from our point of view, it's people who are professionals in that field and can demonstrate that. People who've got experience of it in the past and can demonstrate that, rather than any other way. I mean, I don't know if anybody else has got any experience of this.
Just from our point,
situation where someone's challenged the competence of someone who's taken part in an ES. I just think if you set out your qualifications and experience properly, then it'd be very strange for someone to try and challenge that unless something very strange was going on.
Yeah.
Yeah, I agree. We again at Barton we haven't seen anything being challenged yet on that point either. But yeah, if we just demonstrate that, you know, any qualifications, any professional bodies that the consultants belong to that are clearly written in the ES, I don't think it's that challengeable.
Cool, great. Okay, thank you. Hope that answers your question. Next one's from Andrew Dorian, and a question for anyone on the panel on air quality. What is the panel's view on air quality appraisals as part of SCA or wider strategy development? On the one hand, we have government saying build, 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 and having a clear direction to simplify regulation but placing compliance to the local authority. And on the other hand, major court challenges to plans and activities. So anybody from the panel?
I haven't got any experience on air quality, sorry.
Oh, okay. So anything on air quality there in the context of build, 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 and whether it's been sufficiently appraised?
Well, the only thing I can think of to say is that there obviously is an inherent challenge between inherent tension between those two things, and we're going to have to work it through. I mean, we've seen local plans fail in relation to air quality issues. We've seen significant development proposals come unstuck because of air quality challenges, particularly when you've got down in the Thames Basin, Heaths, SPA area and so on. So there clearly is an inherent tension in that, and we'll just have to all work it through and see how it pans out.
Lovely. Thank you. Okay, I've got another one here. I think this relates to the sort of uncontroversial measures, I guess, in terms of mitigation, you know, things you could offer up front there. What are the environmental mitigation measures which are considered the sort of default other than legislation? So, you know, what things are generally uncontroversial in terms of what you could offer up as mitigation, you know, at the early stages?
Well, I mean, from my point of view, without getting into sort of the specifics of any particular topic, anything that is routinely dealt with by way of planning conditions and has been for a sufficient period of time that everyone knows that schemes of that nature are possible and can be effective, then you can deal with them as part of the screening exercise. Where it becomes difficult is where you've got a proposed mitigation measure that has some degree of novelty about it to mean that you can't be certain that it's going to succeed. I think that's the watershed between the two, that as far as I can see it.
Yeah.
Thank you. Yes, Sue, anything else to add? No? Or just nodding in
well, well, just there's a lot of standard mitigation that goes in. Well, I mean, my experience in terms of minerals and waste developments and wind farm developments, particularly around the construction phase and construction method statements. So yeah, I think local authorities and developers are both getting quite attuned to what to expect to see in terms of mitigation now, well, on those topic areas anyway.
Smashing. Okay, and I've got time for one more question. If a local planning authority receives an environmental statement, what sort of things should they be looking at when reviewing it to make sure it is an regs compliant environmental statement and to identify any gaps?
So, I mean, from my point of view, when you kind of get an environmental statement just to check if it's adequate, it should be a fairly quick check, and it's looking through like the contents page, I think, in the first instance as quick as that, and to make sure that, you know, where there was a scoping opinion, you can clearly see how that's been met, that there is a detailed site description, that significant effects, how they're going to be identified is set out, what the details of the proposed development is, what a description of the site is, that kind of thing, what reasonable alternatives have been looked at, and where it sets out the description of the likely significant effects, where it identifies mitigation, that there is a non-technical summary, and that it's identified where there are omissions in the report. So that kind of thing is just, well, a list off the top of my head.
Okay, that's great. Thank you. I hope that's helpful. Brilliant. Right. Well, we've run slightly over, but I don't think that's any detriment to the quality of the morning. We've had a very good session here. Thanks you very much to our speakers. Without you, we couldn't do this. So, you know, we really appreciate your time on this. Thanks to everybody who's attended and contributed, questions and just listened. I hope you found it useful. And we hope to see you again very soon at another RTPI Northeast event. And I wish you all well.
Thank you.
Thank you.
Thank you.